Hello, I am Surya Subedi. I am Professor of International Law and the author of the study guide on International Law of the Sea. As you would have known by this time, the study guide has 4 sections, each of them dealing with some important areas within the law of the sea, and each section has 4 chapters dealing with the different components of the major theme covered in that section. This section, section D, deals with the high seas and the ocean flow. The high seas, where the freedom of high seas apply, including freedom of navigation and number of other freedoms, as well as the ocean flow, which is known as the common heritage of mankind, where scientists discovered in the 1960s that there was a substantial amount of deposits of magnesium noodles and number of other resources which could be exploited by companies with advanced technology and the financial resources required for it. Since the fear was that those states with advanced technology and financial capability will start exploiting the natural resources to be found in the area traditionally regarded as the high seas, there was an attempt to regulate the activities of states in those areas. As a result, in the late 1960s, the notion of the common heritage of mankind was conceived, which found its expression in the 1970 declaration of the United Nations General Assembly, declaring the ocean floor and the high seas above it as a common heritage of mankind. That concept eventually found its way into the 1982 Convention on the Law of the Sea, which has an elaborate mechanism designed to exploit the natural resources of the ocean flow and then distribution of the proceeds generated from the mining activity. It has created a seabed mining authority with some special rights given to so called pioneering investors. Those investors which had already invested substantial sum of money in the exploration of the ocean flow. Therefore, section 8 begins with an analysis of the notion of the high seas, its origin, the rights of coastal states and non-coastal states in the high seas. When I say non-coastal states, we also include the landlocked states. Landlocked states have no rights except for the right of in-ocean passage if they have their vessels in the territorial sea, with some fishing rights out of the total allowable catch in the exclusive economic zone, but they have full rights. They are able to enjoy full freedoms as any coastal state in the high seas. With regard to the activities in the deep sea bed, the deep sea bed mining authority, which will have carried out the activities, any profit generated will be distributed amongst all the contributing states parties to the 1982 Convention on the Law of the Sea. That will of course depend on the contribution made by them, and there is a provision, I must say, in the 1982 Convention to have a special regard for the interests of developing countries in general and the least developed and the landlocked countries in particular. So, this is a rather elaborate system. I have not come across in international law such a comprehensive treaty with such an elaborate mechanism to exploit the natural resources to be found in the vast areas of the seas and oceans of the globe, whether it is under the Indian Ocean, Pacific Ocean or the Atlantic Ocean. So far as the high seas are concerned, they are regulated by a number of provisions in the 1982 Convention on the Law of the Sea, and one of them says they are there used exclusively for peaceful purposes. So, what do we mean by the term peaceful purposes? What are peaceful activities and which are non-peaceful activities in the high seas? Is the carrying out of nuclear weapon tests is legal, or some sort of military maneuvers legal? Are they for peaceful purposes or non-peaceful purposes? So, there are these issues still being debated today. The final component of section D deals with the resolution of disputes relating to the international law of the sea. The 1982 convention has a rather elaborate mechanism again for the resolution of disputes in the law of the sea, and it provides for a number of options for states, and one of the options is to refer the disputes to the International Tribunal on the Law of the Sea, known as ITLOS, having its headquarters in Hamburg in Germany. That tribunal has started to flesh out some of the provisions of the 1982 convention. The cases decided by the Law of the Sea Tribunal are very helpful in having a better understanding of the rules of the 1982 convention of the law of the sea. And in this study guide, in section D, I have made an attempt to introduce you to these various evolving notions, evolving patterns of interpretation of the provisions of the 1982 convention on the law of the sea. Thank you.